Hey guys, this is Kristen Ishihara and Chris Parker. We're with Ishihara and Parker Law Firm here in Longview, Texas. This morning we are talking about holographic or handwritten wills in the state of Texas and how you do one, should you do one, and all fun things related to handwritten or holographic wills. So we do want to kind of start and just recap where we've been so far, which is talking about how you can do a will in Texas. There's two different ways to do a valid will in the state of Texas. We did a video last week on how you would do a formal or attested will. So a will that contains your wishes and that is witnessed by two people, and how to do that with a self-proving affidavit, which adds a notary. That would be the one that hopefully you would do in a lawyer's office. A holographic or handwritten will is the other option on how you would do a will that is valid in the state of Texas. And so we're going to talk about that today.
Yeah, the DIY approach to will writing, which we will not recommend, but understand that Texas law has given you the option or the ability to engage in this kind of activity. I see it all the time where people come in and say, hey, I may or may not have a will, and that is a bad way to start a conversation.
Right. Well, but if you are going to do it yourself, a holographic is actually an easier way to do it without messing it up, in my opinion. So if you hate lawyers and you're never going to see one or pay one, then this is actually a better way probably for you to do it with less room for error.
It's more, I think, if when your family members show up after you passed away and they walk in and say, we may or may not have a will. They told me on the phone what they want to happen. No, they text me it. Yeah. Probably not. I've seen written on the back of cereal boxes, all sorts of things.
We were getting on a plane together, us and our adult kids, all traveling together. So right before we got on the plane, we wrote something down. We both signed it.
Yep.
Nope.
Yep. All right. So what does it take to do our own DIY will on our own in Texas? The not recommended version.
That's right. So if you were going to have a holographic will, what that means is that it is all in your handwriting. That's how we make it holographic to meet the statutory definition. However, that's pretty confusing. Doesn't give us a lot of direction, right? So what do I write? How do I make it my will? So in Texas, to have a will, you have to be 18 years of age. You have to be of sound mind. And that's a little tricky sometimes, right? Because if your loved one has been diagnosed with dementia, can they be of sound mind?
Sure.
Yes.
And it's also certainly an issue for the person later probating it, because now you have no witnesses that you would with an attested will.
Right. So with sound mind, what you're looking for is that the testator knows their family. Mm-hmm. That's why often a will recite who their family is. That they know their property. So, in a typical client conversation, we ask people, okay, tell me about assets that you own, mm-hmm. because I'm recording not just for the sake of knowing, but also so that I can assess whether you have capacity to make that will or not. And then number 3 is that you have an intent to dispose those assets upon your death. So your will has to clearly say, at my death, I want my stuff to go to this person or these people.
A laundry list with no more is not going to be sufficient. I've seen that before too.
Right.
Car, house, things.
Right. Or my daughter Anna knows what to do. She's in charge.
Right.
Right. So to have a valid will, you're probably 18, you're probably of sound mind. Your holographic will, should you choose to do it that way, needs to clearly indicate your intent to dispose your property at your death.
Yep.
Yeah, but that's an easy one to mess up.
You're going to title at the top, right? Last will and testament, make it nice and clear.
No reason to mess that one up. Let's just go ahead and tell people what it is.
Preferably spell the words correctly. Sound mind, right?
Still
Let's get
intent.
this right. Yeah.
Still intent.
You're going to have your name in this document.
Right. A lot of wills that we've seen that are holographic do not clearly say who the testator is.
That's right.
So if you've signed it at the bottom and nobody knows whose signature that is, it actually can be a little hard to establish, okay, well, this is this person's will. This is a will, because most holographic wills do not say, this is my last will and testament. Yep. This is who I am. Just the very, very basics.
If you're someone like me who has poor handwriting, of course, you're just going to type it up and sign it.
Nope.
Right?
Right. Or have my daughter write it down and I'm going to sign it.
Another classic mistake.
You cannot, we cannot emphasize enough, holographic means in your handwriting. If anyone else's writing will be on that page, you are back to option number 1, which is an attested with 2 witnesses will. You cannot have a valid holographic will that someone else wrote for you that someone else typed up for you that you later signed.
Seen a bunch of those with end of life. You know, someone's frail and vulnerable. They're at the hospital, the nursing home, and you know the daughter's in there and listening to their wishes and handwrites it or types it up and then has the the individual sign it. And of course, the excuse is, well, mom lacked the strength or that kind of thing.
Absolutely.
And I'm like, that's just not. We understand why. We know what happened. We understand why you did it.
Still not a valid will.
Yeah, Texas law is not on your side.
Yep. Got to go back to the 2 witnesses. Right. So there's an option. You can still do it, but you cannot do it as a holographic will if mom cannot physically write it in her handwriting. This is not then the option for you.
Yes.
Yeah. So number 1, label it last will and testament. Number 2, put your name on it. I, Kristen Ishihara, intend for this to be my last will and testament. Very clear. No reason to have questions at the top. Number 3, we want you to revoke prior wills. So I have had cases in the past where loved ones have died, and every time they got mad at somebody or they acquired a new piece of property, they took out a new piece of paper and wrote, I want this to go to this person. That gets very confusing. So you can have your last will and testament plus what's called a codicil, which does not revoke the will but adds to the will. So then the real question becomes, is this a will that's revoking my prior document, or is this a codicil that's adding to that document? And it was very confusing in the cases where I've had people do that very simply. I want this house to go to this person. I want this new lake lot to go to this person. And it was just a new thing every time. It was very difficult to establish what property went to what person.
I've seen it exactly like you said. We have people who come with the original, appears to be original will, and then we have some additions that are added or stapled to it, which can get confusing. Or my other favorite is they come in with the will, and then there's been corrections or changes to the face of the will. Problematic, right?
Absolutely. Well, and because we're going back to the court is trying to determine what the testator's intent was. And if it's not clear, then we aren't able to carry out your wishes. So you do ideally with a holographic will need to do it just once. Revoke all prior wills or codicils. If you need to do it again, I realize that could be a lot of writing. Maybe you should just rethink this as your plan then, because a holographic will should be used in not as an official plan. It should be used in the case of, I can't make it to a lawyer's office. I can't do this at this time, but I will come back later and fix this. A holographic will should be a Band-Aid to a permanent eventual solution. So
this is not plan 1.
Right. Right.
This is not, if this is your plan, your heirs are probably going to have trouble.
Right. Well, and let's remind, so if, like in the case where I had one that said, I leave this house to this person, I leave this lake lot to this person, he had another piece of real property left to somebody, but then he failed to say where everything else went.
That's right.
Because he didn't think about it, right? So if I either don't have a will at all or my will fails to say who gets everything else, what happens?
I have to go to the court to decide what happens to those leftover items. Usually intestate laws of Texas would control that, but it's going to involve the courts. It's going to involve hearings. I have clients all the time say, well, Chris, all I own is my car and my house. I had a client one time, had no real assets. We were just taking care of her estate planning, and we did a will, and heaven forbid, but she died in a wreck that wasn't her fault. Well, now we had a lawsuit afterwards. Where do those proceeds go? After death assets, or because of death assets, have to be distributed. That's your residuary clause. It's very important that you wrap it all up saying, hey, and anything I missed goes to who or whom. And if the people you named are deceased, does it go to their descendants? Does it go to another party? Does it go to a charity? These are all simple thoughts. This is an easy plan when everything works perfectly and everyone dies in order and there's no special events. For all the rest of us, this is problematic.
Right, and that's, I think, what a holographic will really fails to provide for. So you want to make sure that you leave any specific bequests so that if there are things you want to get off the top, this goes to this person, but then we keep calling it a residuary. Somewhere in your will, you need to leave 100% of all the other items you own at time of death to a person or people that add up to 100%.
Absolutely. So
to my 3 children in equal shares, to my 1 best friend, to whoever you want to leave to, but it needs to add up to 100%. So it's clear at the end of the day where those items are going to go, and there's nothing that you've missed taking the opportunity to decide, because if you don't, Texas law will do it for you. Yep. So you have to include a residuary. And then what's so hard about holographic wills is if you get to that point and you've done it right, that's great. But like Chris said, there is no backup plan in there. You just don't have the space or the capacity for it. Sometimes people, they call us and they say, well, we want a simple will. Well, absolutely.
Sure.
But at the end of the day, we have to provide for, if your child predeceases you, we have to say, or we should say in the will, what happens to those funds. Well, does that mean then that there would be a minor that would receive something? Because if so, your will should include contingent trusts for minors that are under 18, because failure to do so results in what?
We can't give to a minor, so now we're looking at guardianship of a minor, another court cost, another process, more attorneys involved, more delays.
Right. We've had multiple clients that had either a will or no will, and an individual died. Of course, this is unexpected usually because they're younger, so they pass away with a will or without. That's a probate cost. Yeah. They've left minor beneficiaries who are not provided for, so that's a minor guardianship, one for each minor child. So however many minor children are involved, one probate plus one for each of the kids.
In the counties where they're located. So it could be Smith County, Gregg County, Harrison County, Dallas, Houston. These things can get complicated, expensive, and slow.
Right, and we make it as easy as possible for you, but anytime you go to court and you open a new proceeding, that's several $1,000s, just period. That's just what it is. So to provide for contingencies, that's what a holographic will really cannot do very well. You certainly could not draft trust language in a holographic will on your own. I wouldn't even try. But you do need to say specific bequests and a residuary that adds up to 100%.
Okay, let's say I do this. I title it right. I have my name in there. I have my intent to distribute. I have given a specific bequest. I have a residuary clause. I've spelled things correctly. I've laid it out. I've even signed it. I've even dated it.
Yep, that's the important part that we've not mentioned yet. Sign it.
In my own handwriting, not a stamp, not anything like that. Don't tape on an old signature. You've got to sign it in your own handwriting. I've done all these things. Who did I leave in charge? How does that matter?
Yeah, so very important. So even if you put all those things together, if you fail to name an independent executor, then someone will have to ask for an administration that's not serving as your executor, and then the court has to determine whether they get to be dependent or independent. So the language here is so critical and really just, specific to the legality of a probate. It would not be something you'd figure out on your own just using common sense. But in your will, you really need to name an executor and a backup. But then because you're in the state of Texas, we want you to name them as what's called an independent executor. Why is that important?
Independent executor allows them to move through the court system without going through court oversight for every transaction. It allows them to fulfill your wishes in a much cheaper and faster manner. If they're a dependent administrator or not independent executor, they're going to have to file with the court. They're going to ask permission. There's going to be notice requirements. It slows down the process, adds to the complexity and cost.
Absolutely.
Of someone you've now roped into your process, and you are dead.
That's right. Well, and if I've named just the executor but not an independent executor in the will, how I've made their life harder is they have to get all of the beneficiaries to agree in writing with a notary that they can serve independently. So not only have I left them in charge of my holographic will that will have additional probate requirements to have it admitted, now I've got to find all those people and get them to agree to allow me to serve independently and present that to the court. Otherwise, I'm stuck doing it the dependent route.
Yeah, and I would just say, so when it comes to these holographic wills, yes, Texas has given you the ability to do these, right? But if you don't follow the rules, Texas is very strident on the results being not great. But there are some people that this is automatically always going to be a bad idea for, right? Those with minor children?
Yes.
Those with disabled children?
Yes.
Blended families?
Well, so I could, if I were able to have a valid will, I could say probably I leave it all to my spouse. So it could be done validly, but if I am a spouse in a blended marriage, one thing I'm going to be sure that I have is a valid will for my spouse that I can probate upon their death so that I own the assets that I
think I own.
Right,
Remember,
need to own.
Because we know under intestate succession laws of Texas, if the will fails, your half of the community property goes to your children, not your surviving spouse in a blended family, which can be all sorts of complications or costs involving the home, the assets you've acquired for the last 20 or 30 years. We're not sure what you're going to do, but understand that if the will doesn't work, your spouse has tremendous problems.
Yeah, it's just not an area I would gamble in.
Out-of-state property?
Well, that's in general
Yeah.
for a will, yeah.
So all these things are reasons why we're definitely people should focus more on a tested will.
Yeah, absolutely. Well, just to make sure that you don't have errors in it. The additional complications that you leave the individuals with when they are trying to probate a holographic will is that they have to bring someone that can have personal knowledge and testify to your handwriting. And that's honestly getting harder and harder these days. It cannot be the applicant. So if they are your executor, they cannot also be the person that swears that this is your handwriting. They have to be able to bring somebody else to do it. And it doesn't sound like that would be hard, but how many people really recognize your handwriting these days?
And what happens to your handwriting as you age?
Absolutely.
I mean, I have clients come in every couple of years, and you can see the difference in their writing as they've aged. And if you're talking about someone who's frail or even on their deathbed, heaven forbid, is that his scribble?
Yeah.
Is that his mark? I don't know. There's no witnesses.
Yeah.
No, there's no
It's a little
notary.
harder. As long as everybody's in agreement, you probably can get by that hurdle. But if there were to be any sort of contest, that would be a serious, significant problem that should be avoided. Chris, do I notarize my holographic will?
Oh, man, what a not great idea. Do not do that one. Wholly in your handwriting means nothing else.
Right. And that people do that all the time. I wrote my own will and I took it to the bank and I got it notarized. You just invalidated what was probably a holographic will that was valid to start with. Please don't do that.
It sounds right.
It does.
But you're blending the two different types of wills.
That's right.
State of Texas laid out the law. The requirements are to be followed. If not, State of Texas will punish you.
Yeah. Well, so let's summarize. So if I were to write a holographic will, not recommended by Chris and Kristen, but if I were to do that, it needs to be all in your handwriting, signed and dated by you. You should write last will and testament on the top, say I, state your name, revoke any prior wills, make any specific bequests you need to. I leave car A to child 1, I leave car B to child 2, and then include a residuary. I leave everything else to both of my kids in equal shares. Ideally, maybe throw in if one of them predeceases me, then to their kids or back to the other.
Yep.
And then name an independent executor and list at least one backup. And then sign and date it. And then your original needs to be somewhere where that executor can locate it, because that's what they'll need to submit to the court.
And how many originals do I have? Right, so I'm not going to write a will out for each child. I have 3 kids. Here's a will for each of you to have. There's one will.
Yeah.
One will, y'all.
And I wouldn't. Sometimes people do additional letters where they want to express something to their kids. If you are doing a holographic will, I would not then also include, heartfelt letters to your children, just because I would be concerned that you would be confusing what those were.
Absolutely.
So, yeah, you have one valid will at a time, and you should be revoking prior ones.
Yeah, and when you mean revoking, we mean...
Yeah, physically destroying, yes. When we revoke a prior will, our suggestion is you either need to mark it through, like scratch on it and write void, or physically destroy it. So we want to be very clear about what your wishes are, so there's not an argument. Child 1 that got everything in the first will pops up and says, well, Mom still had this will. We want to be real clear that you were revoking it, and that was your intent. Otherwise, we've set up a conflict and a contest between 2 existing wills.
Courts love those.
Yes, also a good reason to be careful about how and when you share the will. So, if you're confident you're not going to be making changes, feel free to give copies to the kids. But if it's something that may change.
Yeah, I mean, at least when I talk to clients, I tell them all the time, listen, there's what you want your family to do, and there's the law, and they're not always the same thing. But if you have a solid, good family relationship, then I think laying expectations
Absolutely.
is a wise idea. If there are no surprises, let's say it's a blended family, dad has 2 kids, mom has 1, and they've decided to treat all the kids equally, right? Everyone's getting 1/3, 1/3, 1/3, not 1/2 to 2 kids, 1/2 to 1 child, right? They're treating everyone the same. If this is an ongoing relationship for 20 or 30 years and the children have known the plan for 20 or 30 years, I don't really see problems in those situations because everyone knows mom and dad's wishes. They've been clear from the start, and those are followed through. Now, I've seen other situations where it's World War III, no one gets along, we have ongoing fighting. That would be a different scenario. But in the situations where you can set expectations and you expect them to be followed and the kids will honor them, I think it's a good idea to prime the pump. Let them know it's coming if you have that kind of family situation.
Yeah, well, and you know your family better than we do. It is very fact specific, but pros are people know what to expect. Cons are changing it ruffles more feathers. So
Absolutely.
Something to consider and have a good conversation about. And always keep your original in a safe spot where your executor can access it, knows that it exists, and how to get into it.
That's right. You do all this work and the will disappears.
That's right. Of no benefit at all.
That's right. And the other problem is, you can all have wonderful kids and even wonderful stepkids. It's the people that marry. That's where I see those problems. So,
yeah.
Anyway.
All right. Well, that's all that we have for today. Thank you guys so much for joining us, and we will see you next time.
Thanks.